Hello, everyone.
I'm Monty Cole, and I'm the Moot Court Administrator, and this is Sapphire Carter. And Sapphire, by all estimations, was my co-administrator this year, so I'm super grateful for all of her help. She's to thank for the panels and all of the planning behind the welcome and round dances just across the way here in a minute. But I'd like to start by calling out our final round panel just to come out of their chambers. They wanted me to say, oh yay, oh yay, oh yay. So next up, I'd like to call Brock Flynn. He's a 3L with me, and he's going to introduce our problem authors and then introduce the final round of judges. And then we'll announce the final two teams.
Hello, everybody. Welcome. Thank you for coming. My name is Brock Flynn. I am a 3L here at UM Law and a member of NALSA. Before we start, I'd just like to say that this presentation is being recorded by Missoula Community Access Television as part of a media assistance grant donated to our organization by MCAT. I'd like to introduce our problem authors. Professor Michelle Bryan. She grew up in farming and ranching communities in the West and was drawn to the fields of natural resource and environmental law. She teaches in the University of Montana Law School Natural Resource and Environmental Law program. Is a faculty advisor to the Public Land and Resources Law Review and a water law expert. Her scholarship focuses on the protection of sacred waters and landscapes, state, tribal, natural resources reconciliation, local, federal, land use collaboration, and the relationship between land and water use, water rights, legal systems, planning in an age of climate change, the balancing environmental and land use rights, and the role of public trust in water use. Professor Kekek Stark is Turtle Mountain Ojibwe and a member of the Mizzou clan. He is a professor at UM School of Law, where he serves as director of the Indian Law Program and the Marjorie Hunter Brown Indian Law Clinic, and also serves as a faculty advisor for Public Lands and Resources Law Review. Prior to coming to Montana, Professor Stark served as Attorney General for the Lac Forte Oreille Band of Lake Superior Chippewa Indians, as a policy analyst in the Division of Intergovernmental Affairs for the Great Lakes Indian Fish and Wildlife Commission, and as a policy analyst for the Bad River Band of Lake Superior Tribe of Chippewa Indians. As a practitioner of Indian law, Professor Stark has first-hand experience in training students in how to work productively with indigenous principles and procedures. Along the way, he has helped students and communities forge better relationships between indigenous and non-indigenous institutions and peoples, strengthening tribal sovereignty. So our problem author, do you have any remarks?
Thank everybody for putting the time in and looking at a very complex issue dealing with tribal law, federal Indian law, obviously water law issues, delegation, co-management, property use. Good luck with the final round.
I think we wanted to create a scenario of something brand new because the problems we face require innovation, and it was a great honor to turn that problem over to incredible students, coaches, and bear witness to what they did with the back. Thank you for accepting the problem.
I'd like to now introduce our final round judges. Denise Juneau, she is a member of the Mandan, NNALSA, and Arikara tribes and a Black descendant. Ms. Juneau has spent her career in public service, fighting educational injustice, investing in opportunities for institutionally underserved peoples, and tearing down the pillars of systemic inequality. She is a UM Law grad and is clerk on the Montana Supreme Court. Shane Mourgeot. Mr. Mourgeot is a member of CSKT and serves as the Public Affairs Officer and General Legal Counsel for CSKT, and is also a member of the Montana Legislature. He is also a UM Law grad and holds an LLM from the University of Arizona. The Honorable Eldina Berdomois. Ms. Berdomois, affiliated with the Absoluta, Federated Salish, and Coogee tribes and the Chief people. She is a UM Law grad and holds an LLM from the University of Arizona as well. Ms. Berdomois started her public practice as a public defender for the state of Montana and also spent many years in private practice. She is currently the Conflict Defender Division Administrator for the Montana Office of Public Defender. We have April Ubi-Roll. Ms. Ubi-Roll is a member of the Fort Peck Assiniboine Sioux tribes, is a graduate of UM Law. Following law school, she clerked for the Honorable Brian Morris of the United States District Court for the District of Montana and for the Honorable Sidney Thomas of the Ninth Circuit. She spent 4 years as a litigator at Munger, Bowles, and Olson, filing numerous amicus briefs supporting tribes, members of Congress, national Native organizations, and professors and scholars of federal Indian law. We have Professor Heather Whiteman-Runsham. Professor Whiteman-Runsham is an Absoluta tribal citizen and is the director of the Tribal Justice Clinic and associate clinical professor at the University of Arizona College of Law. He teaches courses on tribal water rights, tribal courts, and tribal law. He is a graduate at Harvard Law School. We have Professor Matthew Ellen Fletcher. He is a member of the Grand Traverse Band and is the Harry Burns Hutchins College Professor of Law at the University of Michigan Law School. He teaches and writes in the areas of federal Indian law, American Indian tribal law, constitutional law, federal courts, and legal ethics, and is a graduate of the University of Michigan School of Law. We have Ryan Rushy, who is a member of the Fort Peck Assiniboine Sioux tribes. He is a partner at Sanofsky Chambers, grew up on the Fort Peck Reservation and graduated from the UM School of Law. And we have Dana Jackson, who is in-house counsel for Federated Salish and Coogee tribes. She previously served at the Biden administration as senior counselor to the Assistant Secretary for Water and Science and the BLM Director at the Department of Interior. She has worked primarily in the areas of Indian water and natural resources law. Let's welcome our judges.
So there's enough suspense. Some of you probably concluded, given the composition of the panel, about the first team to advance. That's team 86. They will be calling the coin toss based on the seating. So the coin toss means if they get heads or tails, they get to pick who is, which side they're
Petitioner.
petitioner.
And we also would like to call up Team 183.
Please proceed.
All right. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the court are admonished to draw near and give their attention, for the court is now sitting. You may be seated.
Okay, petitioners, we can start. Yeah, that'd be fine. Yes, please proceed.
Okay, please support. My name is Shambi Martinez, counsel for the petitioner. This case is about farmers who are in danger of losing their livelihoods. Families who have lived and worked in reliance of the water here for over 100 years, and who have had no agency in the tribe's decisions in administering this water here. I will address the threshold issue and show that the tribe's sovereign immunity has been waived by both the McCarran Amendment and the tribe's own constitution. My co-counsel will show that this is an improper delegation of authority. This court should find in favor of petitioner and grant declaratory and injunctive relief on behalf of the Dakota Farm Bureau for 3 reasons. First, this case is a McCarran Amendment case, as there is clear legislative intent that tribes can be joined under the amendment, and the Dakota Farm Bureau here is requesting an administration of water rights. Second, by using tribal law in its management decisions, the tribe is in effect invoking its tribal constitution, which provides a waiver through the rule of reciprocity. Third, even if the tribe cannot be joined, this case can still go on as the tribe is adequately represented by the remaining federal parties. Tribal sovereign immunity is an evolving doctrine. Past sovereign immunity this case has dealt with situations with payday lending and casinos schemes where tribes have used sovereign immunity as a bar with contracting parties. But unlike the precedents of the past, this case is not about 2 contracting parties. It is about one party unilaterally making decisions for another party who has never entered an agreement with that party.
Counsel, is this a due process case or is it a sovereign immunity case? You're conflating 2 different things.
Your Honor, this is a sovereign immunity case.
Okay, so what does it matter if you have a say if the tribe is immune from suit?
Your Honor, this is just to go to the reliance argument that the farmers are promulgating and the fact that there has been no discussion in the delegation of water with the farmers, which is contrary to its contract with the federal government. So,
For question, Counsel, I'm from a eastern state, Michigan, and we don't have the McCarran Amendment issues. And can you tell me, does the McCarran Amendment actually expressly abrogate tribal sovereign immunity?
yes, Your Honor, it does expressly abrogate tribal sovereign immunity, which is required by sovereign immunity case law.
Sure.
So when we look to the McCarran Amendment, we see that the McCarran Amendment was essentially created to
But what's the text of the language in the bill, or the act that says that?
the text of the act says that the McCarran Amendment may join the United States in administrations or adjudications of water rights. However, when we look to sovereign immunity precedent case law, we can see in Lac de Flambeau v. Band of Lake Superior Chippewa v. Coughlin that this court has similarly held that statute can, Congress can find there can be waivers of sovereign immunity within statutes.
But counsel, the McCarran Amendment addresses the federal waiver of sovereign immunity, and it doesn't say tribes. It doesn't say tribes at all in the McCarran Amendment. Isn't that true?
Yes, Your Honor, it doesn't say tribes at all, but that is not a requirement under sovereign immunity case law. So again, going back to Lac de Flambeau.
How is that not how is that an express, not express?
Yes, Your Honor. So Going back to case law, there doesn't need to be a magic words requirement, so tribes don't necessarily need to be mentioned by names.
But
in
counsel, there must be a clear statement, correct?
Your Honor, the standard is that Congress's intent must be clear. So here, the McCarran Amendment, although we don't have the magic words tribes in this case, we can look to the legislative record, the legislative history, and look for that waiver of sovereign immunity.
But counsel, you said earlier that that in the tribal constitution, they waived it. So what does it say in the tribal constitution about their decisions to waive any kind of sovereign immunity?
So, Your Honor, there are two pertinent parts of the Constitution at issue here. So the first is Article 16, which states that the tribe is immune for suit except for what is provided in the Constitution. And the second provision is Article 6, which states that the tribal council shall ensure that the rule of reciprocity controls. So here, we are saying that by invoking tribal law, the tribe must also follow their own law, and the rule of reciprocity is ingrained in the tribe's legal code, which here we are contending that it's being violated by such a significant cut to the farmers' water supply, which is 50% in the driest summer months of the year, which is going to be devastating to their livelihoods. So going back to the...
Counsel, even if, oh, go ahead.
Counsel, I'm just curious, if you're going to talk about tribal law establishing a waiver of the tribe's sovereign immunity, in the text of the Constitution, it says that the tribal council can provide waivers of the sovereign immunity. And I don't see anything in the record that shows me that the tribal council has really deliberated at all as far as the sovereign immunity of the tribe. So can you explain to me how we would infer that from the rule of reciprocity, which I don't believe says anything about making the tribe vulnerable to suit in a federal court?
So, Your Honor, although the text does say that the tribal council shall ensure that the rule of reciprocity controls, other courts have found waivers of sovereign immunity when you look at provisions like this in conjunction with one another. So we can see from the record that there is no other possible area of redress within the tribe's constitution itself. And we can look to fundamental fairness standards that tribal courts have held require an avenue of redress, which is similar to the rule of reciprocity in this case.
If we're going to talk about fundamental fairness, if the tables were turned and if the tribe here were trying to assert an enforcement action or get declaratory relief and enjoin the administration of water to meet the needs of Dakota, or what is it, the Farm Bureau, would the tribe be able to come to federal court and ask for relief if they were the ones here seeking to have their rights fulfilled?
Your Honor, yes, the tribe could always bring an action in federal court in order to have their rights fulfilled.
Well, but their rights aren't even decreed and adjudicated. And in other federal actions, tribes have been denied redress when they don't have a quantified decreed right under things like the standing doctrine and other limitations there. So if we're talking about fundamental fairness, I don't know that I follow your logic here.
The fundamental fairness idea is it is narrowed to tribal courts in the way they have interpreted waivers of sovereign immunity within their own constitutions. So that idea is just very narrowly as applied to this idea of the rule of reciprocity here, acting as a stand-in for the tribe's legal code and as acting as an avenue for which parties can have redress against the tribe.
So, counsel, did the tribal court here make a determination on that? Did the council make a clear determination? Has that been adjudicated within their own tribal system?
Your Honor, it's not clear from the record whether the tribal court had any input on this. The district court potentially could have asked tribal members to come in. Potentially the tribal council could have come in and outlined what the rule of reciprocity meant in their constitution. So we do have some facts in the record explaining what the rule of reciprocity is meant to mean to the tribe. However, there's no facts saying that there was or wasn't input from the tribal council.
Counsel, it sounds like you're asking us to interpret and apply tribal law. What is your best case for the proposition that this body is competent to hold that the tribe is violating its own law?
Your Honor, the federal courts are courts of general jurisdiction, and they've been able to interpret foreign law and state law in different cases. So we would argue—
You're saying federal common law is the way for the Article 3 courts to interpret tribal law?
No, Your Honor, I'm saying that federal courts can interpret other laws within from other foreign bodies, so the tribe in this case. So we've seen federal courts interpret law from different countries even in the United States. So it's not too much of a stretch that the federal court here.
The tribe, you know, the United States has a duty of protection over tribes, not other foreign nations, and Martinez teaches us that the Supreme Court's not going to interpret tribal law.
Well, Your Honor, the Supreme Court has interpreted tribal law in the past, so it's not too much of a stretch here to say that they could interpret tribal law in this case.
But you're not just asking us to interpret it, you're arguing that the tribe is not following its own law. And so my question is, in what situations have we previously determined that another sovereign is violating its own law?
Your Honor, this is a unique case, but we can still look to other court cases in order to find a waiver here. So we can look to tribal court authorities in order to, and apply them in this case to decide whether there is a waiver. So it's not, we can look to.
Counsel, if there really are two competing interests here and the federal government is responsible for some of the interests, water interests here, why should this matter simply not be remanded and determined through agency action?
Your Honor, this case must go on because this is such an imminent situation for the farmers. The tribe has already cut water to the Farm Bureau. There's decisions have been made as to where the water is going. So this case needs to go on here because it's an imminent threat to the farmers' livelihoods. If the case was deferred or switch to another forum in the interest.
But let's say we do that. Let's say we dismiss all of this and kind of remand the case back to tribal court or a tribal forum. Would that be satisfactory to your clients?
No, Your Honor, because here we have both federal interests as well as tribal interests at hand here. So as courts of general jurisdiction, this is the best forum.
That's a good point, counsel. Let me ask you this. Do we need to resolve the question of tribal sovereign immunity in order to have the outcome that you're seeking here today? Do we need to get to that question?
No, Your Honor. So this case can still go on without the tribe because under Rule 19 of the Federal Rules of Civil Procedure, the case can go on if the remaining parties can adequately represent the party that cannot be joined. So yes, the case can still go on even if sovereign immunity is barred.
So under your view, the United States would essentially be representing the interests of the tribe here?
Yes, Your Honor, and we can look to authority in this case, like this court's holding in Colorado River Water Conservation District of the United States. So in that case, this court held in relation to the McCarran Amendment, the United States can represent federal water rights reserved water rights on behalf of tribes. So we see that this court has already held that in situations like this, federal parties can adequately represent the tribe's water rights. And we can also look to the trust obligation that the federal government has.
But isn't the policy behind Rule 19 that an absent party shouldn't be held liable when they can't be present to defend themselves? Aren't you asking us to basically hold that the tribe can't do what it did? I mean, how can the United States adequately represent the tribe's interests there?
Your Honor, the United States can still adequately represent the tribe's interests. They have done so in numerous previous cases.
But you're not asking us to invalidate something. Well, you are asking us to invalidate the delegation potentially, but you're really seeking to invalidate the tribe's allocation. So I'm not really following how the United States would be the party that is sort of held liable or losing something here.
That's because we're bringing this claim because the federal government, we're contending that the federal government's delegation is unlawful here. So they also need to be a party here, and they can still also at the same time represent the tribe's reserved water rights as this court has held in the past. So, and when we go back to the McCarran Amendment and the policy that the McCarran Amendment was enacted under, we saw that this exact sort of case was contemplated when the McCarran Amendment was enacted. It's this case.
Aren't there issues in state court with having biases against tribal interests? I mean, we've seen cases like the Snake River case where the trial level judge said, I'm not going to recuse because everybody in the state of Idaho has the same interest of water in opposition to tribes, so I don't care. Is that, I mean, should we be concerned about state court bias?
Well, Your Honor, here we're in federal court, so we're just asking for the tribe to be joined under the McCarran Amendment in federal court here, so we don't have issues there with the state courts. And furthermore, for the foregoing reasons, we respectfully request that the court reverse the 13th Circuit's decision and grant the petitioner declaratory and injunctive relief. Thank you. A little shorter than that. I don't know how. Can you hear me? Okay, sorry.
May I proceed? May it please the court. Good afternoon, Your Honors. My name is Annie Lawler, and I am counsel for the petitioner. Our client, the Dakota Farm Bureau, requests that this court reject the holding of the 13th Circuit and find that the co-management agreement is an unlawful delegation of authority to the tribe. There are 3 driving reasons why the co-management agreement is unlawful. Firstly, the co-management agreement is not congressionally authorized and thus is unlawful under the subdelegation doctrine. Secondly, under the co-management agreement, the Bureau of Reclamation does not retain sufficient review authority and thus is unlawful. Lastly, the current status of quantification is a barrier to the tribe's plan because the tribe's rights have not yet been quantified and thus they are not yet tangible in the field of law.
Aren't the tribe's rights still aboriginal? If they haven't been qualified, why aren't they quantified? Why aren't they still viable?
Absolutely, Your Honor. Petitioner does not contend that the tribe's reserved water rights are not viable, merely that in enforcing them without a quantification, there creates problems under the subdelegation doctrine.
The process of quantification is a state law process typically? Maybe not in state court, but a state law process? Yes?
Yes.
Okay, you got to say the words.
Sorry,
Where's
yes.
the transcript? But so it's a state law process, substantive state law. How does state law actually, the tribal treaty rights or tribal rights, Aboriginal rights are federal rights. How can state law change those or modify those?
State law does not modify tribal treaty rights, Your Honor, and we are not contending that state law is modifying those superior senior rights. Rather, the fact that the tribe's water rights have not yet been quantified mean that in this allocation, we cannot be sure that the tribe is only allocating their own water rights. So,
isn't this case premature until those water rights are quantified? I mean, aren't you asking us to jump the gun and make a determination here about whether it's right or wrong without following the rest of the process?
Your Honor, the petitioners are actually contending that the tribe has jumped the gun here rather than waiting for the state court adjudication to proceed where the quantification will take place, and the tribe's treaty rights, senior water rights absolutely, will be contemplated and understood in recognition of the very complex scheme that is water rights in the West, especially with the changing dynamic of climate change.
So doesn't your client stand to actually potentially lose more than what they're asking for here under that adjudication?
Your Honor, the state court adjudication process could certainly come out with a different allocation of water than the tribe is, and the petitioners, Dakota Farm Bureau members, could be injured by that. But the problem in this case is the improper delegation, not the specific allocation that the tribe has made. And we are contending that because those rights have not yet been quantified, that delegation is improper. If we go to the subdelegation doctrine specifically developed in the DC Circuit, in U.S. Telecom Association v. FCC, the court held that in order for an agency to delegate this type of authority to a private party or to another party outside of the agency, there needs to be express congressional intent, clear language authorizing them to do so.
Don't we have that in the Reclamation Act, though? I mean, isn't that kind of the whole point of it, is to reclamation pushes all the responsibilities onto irrigation districts, and I mean, except for their big dams. I mean, generally irrigation projects are run by people like your clients, right?
No, Your Honor, the Reclamation Act of 1902 says nothing authorizing the Bureau of Reclamation to enter into any cooperative agreements with tribes. There is 43 USC Section 373D, which does authorize the Bureau of Reclamation to enter into contracts and cooperative agreements with tribes, but Section 373D is specifically subject to the Indian Self-Determination and Education and Assistance Act. The statute says nothing here intends to modify or expand ISDEA, and ISDEA is a limiting statute. Under ISDEA, tribes are able to manage trust assets, but through a clear procedure. There are two types of contracts. So the first, a self-determination contract. No one contends that that is at issue in this case. Those are mandatory contracts, not relevant here. The second, self-governance contracts, can potentially expand beyond the breadth of a self-determination contract, but those contracts are limited by the necessity that the government cannot delegate an inherently federal function.
So what are the inherent federal functions here that you're specifically concerned about?
Your Honor, it's hard to imagine a situation that is more inherently federal than what we have here. We're talking about a federal project created with federal monies on federal land, not Indian land, outside of the reservation, involving federal contracts. It is really an incredibly federal duty that is at play here.
But aren't water rights adjudicated by state courts? How can this be an inherently federal function?
Your Honor, petitioners are not asking this court to adjudicate water rights.
But in theory, you're challenging an adjudication.
In theory, the challenge is to the delegation itself, not necessarily to the adjudication at play.
I'm glad you brought us back to the delegation. Aren't you sort of jumping the gun here? Don't we need a fiduciary trust? We need to find that there's a fiduciary trust here before we can get to delegation, correct?
Your Honor, petitioner does not contend that the federal government has a trust responsibility and a fiduciary responsibility to the tribe, but that is not a dispositive factor within the subdelegation doctrine. And we can move into that test without specifically looking at it. In other
Counsel, do
circuits,
any of the cases on subdelegation doctrine have anything to do with a tribal sovereign?
Your Honor, in the Ninth Circuit, some of the cases do. If we look to NANS v. EPA and Southern Pacific Transportation Go v. Watts, specifically, the court has a separate subdelegation analysis, but those cases are distinguishable from this because all of those occur on tribal land. All of those are primarily Indian assets. They're occurring within Indian country, which really...
Counsel, I think that there is a tribal interest, a tribal property right at stake here, though. So saying that it's not on Indian land and therefore it doesn't matter seems a little bit disingenuous when the tribe reserved very specific, very significant rights and sticks in that bundle of the property rights when it ceded that portion of its reservation, of its previous reservation. So I think there is a tribal interest here, and I think that there is a reason to find that, some of these arguments about there being no tribal property involved are just not complete and maybe inaccurate.
Your Honor, petitioner does not contend that there are no tribal interests or tribal property involved in this matter, merely that because the tribal interest is distinguishable from those at play in NANS v. EPA and Southern Pacific Transportation Co. v. Watt, this court should analyze it differently. And
where would you draw the line?
Your Honor, I think the fact that we are not on Indian land is dispositive, but more importantly, the fact that the water rights have not yet been quantified. If we go to Hawkins v. Holland, the Ninth Circuit also has a different analysis for tribal management of water rights, but in Hawkins v. Holland, the case is very different. The Klamath tribe was able to make water calls, but the Oregon state adjudication process had been completed already, meaning that the water rights of all the stakeholders in the basin had already been determined. So the tribe was able to make water calls based on those quantification. The rights were determined. As a result, the court held this is within the tribe's inherent sovereignty. It is all right for the tribe to make these determinations. Those are not the facts in this case.
Don't we have cases like out of the 9th and 10th circuits having to do with Clean Water Act, treatment of state status that involve off-reservation, like the application of clean water standards that are promulgated by tribes off the reservation, Albuquerque and Flathead?
Yes, Your Honor, and NANS v. EPA is also concerning Clean Air Act standards. But again, those rights are primarily from the tribe making decisions that are within their authority, and they do impact
non-Indian authority too, though, isn't it? I know the courts went into the Montana analysis, and we could talk about that, but that's really delegated federal authority.
Your Honor, there has been delegated federal authority in some situations, but those, again, are distinguishable from the situation that we have here. In addition, Water is different from the other natural resources at play and from other co-management agreements and management schemes out there. The U.S. has recognized that in the West in particular, water is incredibly complex and really challenging and requires a stable and consistent and reliable.
Council, when we talk about stable, how, in this circumstance, do we ensure that the grand trout continues to be protected on behalf of the tribes?
Your Honor, the state court adjudication process will ensure that the tribe's rights are met and that the fish are protected as a result.
Council, how do we do that right now? How do we protect those fisheries right now?
Your Honor, notably, the fish are no longer on the endangered species list, suggesting that they are not in peril at this exact moment, and there isn't the same urgency regarding the fishery as there is regarding the farmers and the devastation of their livelihoods and of crops.
But Council, if we give you what you're asking for, aren't we just flipping again where we'll be back to having to deal with the trout being threatened because the water will be so low? I mean, somebody's got to maintain for the fish. How will that impact this?
Yes, Your Honor, and the Bureau of Reclamation is subject as well to federal law and to the tribe's treaty rights, so the Bureau of Reclamation can protect the fish without the tribe having delegation authority here. So it is not necessary that the tribe be the one, the managing party here, because the Bureau of Reclamation is also subject to those in-stream
So Council, would you, I guess, would you say you were asking for a de facto quantification of 50-50?
No, Your Honor, we are not asking for a quantification or for a 50-50 analysis. Merely, we are asking for this court to wait for the state court adjudication to determine those numbers.
Can I ask a question on that? So you're saying you want to wait until the state court has adjudicated the quantity of the tribe's water, and you're saying your clients already know what your quantity is, but until it's completed, yours doesn't really matter either, because you know there's a senior user out there, senior water right holder out there that's unquantified. Doesn't that mean until that time happens, you don't get anything either? I'm trying to figure out how one water rights holder can get water and the other one can't simultaneously until there's a final adjudication on everything.
Your Honor, petitioners did not contend that one water rights user can get water and the other cannot. We are not suggesting that we deserve a specific quantity of water either, merely that the state court adjudication process is the proper authority to make these decisions as Congress has determined, and that we should wait for that decision to come out rather than making a decision and then having to change it again, because without that stability, the farmers are not only going to lose their crops while in the meantime, but they also can't make any future decisions.
But as I understand it, I mean, Congress passed this McCarran Amendment back in the 50s, and the state of Dakota's still, and after 70-some years, hasn't finished adjudicating the water rights. But this project, the Sapphire Project, is diverting 100% of the Grand River. Like that seems to me that they're using water, putting it to beneficial use upon which your clients' crops depend before the adjudication is done. And I kind of hear you arguing that, but the tribes can't do something different until the state adjudication process is done. So I'm wondering how you reconcile that.
Your Honor, the water right found within the contracts is authorized to have the full flow of the river, 100% of the Grand Stream, or the Grand River. But that has definitely not been the case, because the fish have survived for the past 100 years. So the right may be for the full flow, but that is clearly not what has been exercised but in the past. And that is why we are contending that the Bureau of Reclamation can maintain their own authority to manage the river, and that the tribe's interests are not in peril at this moment. This also gets to a really critical question of redressability. The farmers here are without any avenue for redress, specifically because the Bureau of Reclamation does not retain sufficient review authority. In National Park and Conservation Association v. Stanton, the court held that review authority must be more than a termination, a final termination, a veto authority. In other words, they went in, the court must be able to appoint the council, determine the committees, determine the interests that are
Council,
found.
I still don't understand why it's so scary to your group, to your client, to go to tribal court or a tribal forum to adjudicate or to address these issues. What's the problem with the tribal forum?
Your Honor, firstly, the farmers cannot wait for that. Secondly, the farmers contend that the tribe would likely, again, assert sovereign immunity in court, and so there would be no redressability. And for the foregoing reasons, This petitioner requests that this court reject the finding of the 13th Circuit and hold that the co-management agreement is an unlawful delegation of authority to the tribe. Thank you.
Respondents.
Good evening, Chief Justice, Justices, and may it please the Court. My name is Justin Schock, and I, along with my co-counsel, Jay Kearney, represent the respondent, the Northern Tribe. Since time immemorial, the Northern Tribe has long enjoyed its sovereignty. Furthermore, this tribe's sovereignty cannot be waived based on the application of the McCarran Amendment, nor can any waiver of this tribe's sovereign immunity be found within the tribe's constitution through the rule of reciprocity. It is for these reasons that this court must reverse the 13th Circuit's holding and affirm that this tribe has not waived their sovereign immunity under any circumstance. Your Honors, the McCarran Amendment does not apply under this case, as the McCarran Amendment's text, which is located at 43 USC 666A, does not include any mention of it extending to sovereign tribal nations. As such, the McCarran Amendment is not applicable under this matter. However, if this court were to look into the McCarran Amendment and based on the rationale of some courts within the Ninth Circuit and determine that it does extend to tribal nations, it will still find that the application of the McCarran Amendment will fail.
Does the clear statement rule about tribal sovereign immunity survive the Coughlin case?
Your Honor, the clear statement about tribal sovereign immunity certainly survives that case, especially if we look to the Klamath Court's holding, which stems from the Ninth Circuit in 2022. The Klamath Court did determine that McCarran Amendment cases concerning the administration of water rights must occur after there has been an adjudication of those water rights.
I don't think you're being responsive to the question. Coughlin is about the Bankruptcy Act. Remember, it says all sovereigns' immunities are waived. It doesn't say anything about tribes. It sounds to me like that's the McCarran Amendment.
Your Honor, perhaps. However, if we look to cases that are more on point to the specific issue before this court today, especially that of the Klamath case, you will see that
Any of those cases post-date the Coughlin decision?
Your Honor, the Klamath case was issued in 2022.
So Coughlin is 2023, right?
That is true, Your Honor.
So do those cases survive Coughlin?
Your Honor, these cases that I've mentioned within the Ninth Circuit would still survive Coughlin because they are especially on point to this particular issue, as they are also dealing with the administration of potentially adjudicated water rights. As the Klamath Court noted in its decision, the administration of water rights may only proceed forward under the McCarran Amendment after that adjudication has been established.
Counsel, when we talk about quantification, to me it seems that this case is really about quantities of water for irrigation, quantities of water for fisheries. How is that not clearly within the McCarran Amendment for quantification purposes?
Your Honor, once again, I would point back to the plain text of the McCarran Amendment in which it does not extend to tribal nations. While His Justice has concluded that in other cases it may extend to other sovereign nations, we must remember that it is imperative to recognize that tribal nations, such as the Northern Tribe, have inherent sovereign immunity. If the individuals who drafted the McCarran Amendment would have wanted it to extend to tribal nations, it would have been clearly expressed within the McCarran Amendment.
Counsel, in this case, though, we see the tribe doing something that's a little bit out of the ordinary for tribal government. They're stepping in and filling the role of what would normally be a federal agency or another federal contractor. And if the tribe wants to take on these roles and assume this responsibility, why wouldn't they want to be held accountable like any other sovereign or contractor would be? Why does the tribe get to be different in fulfilling these same roles and functions than anybody else would be? Because the federal government would be liable would they waive their sovereign immunity to be reviewed, and there are different federal law provisions that give people an avenue in federal court to question federal administrative decisions. Why does the tribe get to be an exception here?
Your Honor, the tribe must be an exception in this particular matter because, once again, they are a sovereign nation, and as such, they enjoy the freedoms of a sovereign governmental entity.
But doesn't tribal law require there to be a remedy here? Doesn't tribal law and the rule of reciprocity require the tribe to be held accountable?
Your Honor, it is true that the rule of reciprocity, located within Article 6 of the tribe's constitution, does provide that the tribe must provide for the river and living beings as the river has provided for the tribe. However, you will see within Article 6 that there is no express waiver of the tribe's immunity within that article. Furthermore, if we look to Article 16 of the tribe's constitution, which states that the tribal council must act in accordance with the constitution, laws, and rules set forth within, it still provides no explicit waiver of sovereign immunity.
So, counsel, if at some point we all have to be good neighbors, right? We're all in the same community. What is the opportunity for Dakota Farm Bureau to get its remedy? How does it get what it needs?
Your Honor, this actually leads me into my next point. As the McCarran Amendment is not applicable in this matter, as the Northern Tribe is its own sovereign nation and is not able to have McCarran Amendment cases asserted against it unless it expressly waives its sovereign immunity, the Dakota Farm Bureau may look to see if the tribe has any expressed waivers within the tribal constitution, which they have done before this court today. However, Your Honors, my friends on the other side have put the proverbial horse before the wagon on this issue, as they have alleged that a violation of the tribe's rule of reciprocity has been done through the tribe's management of the Grand River. This is not the case, Your Honors.
I guess we'll never know because you have sovereign immunity and are not allowing this to be heard on the merits.
Candidly, Your Honor, in situations such as these, and whenever we're looking for tribal waivers within their own constitutions, there would be options in which a tribe could hypothetically waive their sovereign immunity. However, that has not been done under this specific instance, as the tribe has continued to follow the rule of reciprocity by managing the river and
I find it really concerning that you have a very serious issue here in which you're not, this sovereign is not willing to acknowledge and respect in a democratic environment, in an accountable environment, the interests of people that are your relatives, effectively, your neighbors, through the rule of reciprocity or not. And, you know, it's going to take 5 votes for you to survive really a challenge to the very idea of tribal sovereign immunity after this. I mean, you know, Bay Mills was, what was it, 5-4. There were 4 dissenters said there is no sovereign immunity. Why can't we just get rid of it? I mean, this seems like a really good vehicle to do that.
Perhaps, Your Honor, but as you previously pointed out, whenever my friends from the other side were at the podium, the petitioner is asking for this court to essentially determine if another sovereign nation has violated their own laws. This court does not have the purview to do so. This is a matter that should be put before a tribal court.
You don't have to say that. All we have to do is say you don't have sovereign immunity anymore with 5 votes, pure judicial fiat, and that will force you to determine whether or not you're violating your own law.
That is true, Your Honor. That would potentially force the Northern Tribe to determine if they have violated their own laws. However, as noted in similar cases, such as the Decro case, which stems from the Turtle Mountain Appellate Court in 2004, you will actually see that these matters are best decided before a tribal court, which has not occurred at this point.
But counsel, opposing counsel's position is that you'll just assert sovereign immunity in tribal court again. So what would be the sense of that?
Your Honor, tribal immunity in cases in which a tribe has violated their own constitution does not necessarily constitute that a tribe will be able to maintain that sovereign immunity. If a tribal court does find that the tribe has violated their own constitution, that would, in essence, waive that tribe's sovereign immunity and make them immune to suit.
Isn't that in itself a horse before the cart argument? I mean, how does a court decide the tribe has violated its own constitution without deciding the question of immunity first? How could a tribal court ever make that determination?
Your Honor, once again, if we look back to the reasoning of the Decro Court that stems from the Turtle Mountain Appellate Court in 2004, you will see that tribal courts are best appointed at determining what the inherent meaning is between each rule and regulation within a tribe's constitution. So it would be within that court's purview to decide if the rules that a tribe had enacted, regardless if they when they occurred would have been violated based on the tribe's mental mindset at that point in time in which the rule was enacted.
Counsel, let me ask you a question that I asked the opposing counsel, and that is, can we resolve this case without getting to the question of sovereign immunity here?
Your Honor, this case cannot be resolved before this court today, as such matters would require for this court, in essence, to stay the matter, certify the question if the tribe has violated its own sovereign immunity, and send that to a tribal court in which they could issue.
What is the process for this court to certify a question to a tribal court? Can you point me to a provision of the United States Code or a provision of tribal law in this case that authorizes such a procedure?
Your Honor, I can't point you at this moment to a specific section within the United States Code that would allow for this, but I am happy to submit a supplemental brief on that at a later date. However, I would once again point this court back to a decision that it decided in 1985 with the National Farmers Union Insurance Company versus the Crow Tribe of Indians, in which it did find that, as the court had noted within that case, that the administration of justice within the federal court system may only be properly administered by allowing for a full record of such tribal violations of their own constitution to be reached first.
Counsel, but aren't there several exceptions to the exhaustion rule that came out of National Farmers?
Your Honor, it is true that there are several exceptions that did come out of the National Farmers case. However, this matter is unique in its own instance, and we must defer this matter, if the court would want to even proceed forward in this matter, to the tribal court. So
if we were to defer to a tribal court and create a record there, wouldn't that be doing the same thing that provisions in the McCarran Amendment, the whole reason of the McCarran Amendment would be thwarted, because what we're trying to do is to avoid duplication of judicial processes and conserve judicial resources. What good will it do the tribe to create a tribal court record of the same issues that have been underway and under consideration for decades and decades in the state of Dakota?
And I might add, they're not appealable to this court. I mean, they stop that, the adjudication will stop at the tribal appellate court.
These are very fair concerns, Your Honor, which respondent does recognize in this instance. However, if we do look to the specific facts of this matter, we will see that the Northern Tribe has not violated their constitution in any means, especially if we're looking at the rule of
I guess we'll never know, will we? Didn't Congress really intend, in addition to these policies that Justice Whiteman mentioned, that really their interest, the federal government was refusing to go to state court, much like your client is refusing also to go to state court or federal court or any other court?
Your Honor, I cannot speak on behalf of the federal government on why they would not want this matter to proceed forward in a state court. However, I can speak on behalf of the tribe as to why they would not want.
I was referring to the Department of Justice position prior to the McCarran Amendment, in which it would always refuse to go to state court. So Congress vacated that objection, that defense. And effectively, we could argue that it vacated any sovereign's defense that would avoid state court, like your client.
Your Honor, I'm not sure if I understand the question. Could you please clarify?
So the McCarran Amendment was designed to make sure that Department of Justice would never argue that they would never avoid state court adjudication in water rights cases, right? So it's a sovereign that's saying, we have sovereign immunity, we're not going to go to state court. Congress abrogated that. Why isn't that true for tribes?
Your Honor, 2 points on this matter. First, it is true that a sovereign such as the federal government has provided, in essence, a waiver of their immunity through the McCarran Amendment. However, the tribe is not part of the federal government. The tribe is its own sovereign nation. It has its own rules, regulations, and constitution. The tribe never would want to stipulate that the federal government could waive their own immunity in this specific instance. Therefore, they have provided no express waiver or...
Could we just hold that the federal government can stand in the shoes of the tribe? The U.S. owes a duty of protection of the tribes. Nevada v. U.S. says the U.S. can stand in the tribe's shoes and make those determinations for itself?
Potentially, Your Honor, but once again, I would point this court back to the Crow case from 1985, in which it did determine that all other remedies pertaining to tribal violations of their own constitution must be exhausted in a tribal court.
Don't we have the futility exception to that exhaustion rule from Straight versus A1 contractors that said if there's there's no possibility of tribal court jurisdiction, you can go straight to federal court?
Your Honor, yes, that is true. However, in this specific instance of this matter, the tribe has long enjoyed access to the Grand River and the lands within since time immemorial. The tribe has maintained continued access to these lands and is currently managing the waterways. Therefore, they deserve...
Off reservation as well, right?
Your Honor, it is true that they are managing the Grand River in lands that do extend to those off of the reservation. However, if we look into the record, we will see within the various treaties that many of these lands that are no longer part of the reservation were actually ceded to the government.
Well, if we go through the route that you're asking us to and defer to the tribal court and require exhaustion from the Farmers Bureau, aren't we just going to create more adjudication about whether or not the tribe ever had jurisdiction under the Montana test?
Your Honor, I am not sure. Could you please clarify that question?
It's all right, just finish up. It's fine.
Chief Justice and Justices, for the foregoing reasons, the petitioner, the respondent, the Northern Tribe asked this court to determine that the Northern Tribe has not waived their sovereign immunity under the McCarran Amendment or through their own constitution at Article 6 with the rule of reciprocity. Thank you.
May I proceed? Chief Justice, Justices, may it please the court. My name is Jade Kearney, and I appear before this court as counsel for the respondent, the Northern Tribe. The Northern Tribe must be allowed to exercise the rights guaranteed and reserved by the United States.
But counsel, isn't the Northern Tribe exerting its jurisdiction in a place that it doesn't have? Isn't it beyond its own scope right now?
While that may be your first inclination, Your Honor, this is a case of a sovereign affirming subdelegation and is thus entitled to a more permissive review because the United States is entered and has a trust obligation and permissive fiduciary duties to the Northern Tribe. So for the following three reasons, I request that this court affirms the decision of the 13th Circuit. First, when the United States delegates a trust obligation to the Northern Tribe, it's fulfilling its trust duties and therefore is engaging in a lawful subdelegation. Second, because federal and tribal water reservation rights are governed by the federal law, the Northern Tribe does have the right to exercise management over this project. And third, pursuant to the doctrine of prior appropriation, the Northern Tribe's rights to the Grand River waters supersede those of the state and the Dakota Farm Bureau.
Counsel, doesn't Dakota Farm Bureau have a right to water in these circumstances too? Are they expected to have their crops go dry?
The Dakota Farm Bureau does have some rights to the Grand River waters. However, they are a junior rights holder as the state of Dakota was only admitted to the United States in 1899. The Northern Tribe's rights to these waters were recognized in the 1857 treaty and the 1892 land ceding agreements that the tribe has with the United States, making the tribe a senior rights holder that may fulfill and fully exercise their right to the waters in the entirety before the Dakota Farm Bureau.
I want to talk about the junior status part of what your answer just now. Are you saying that, let's say the tribe makes a determination to just completely cut off water to the petitioner? It sounds to me like a taking under, the U.S. Constitution or maybe the tribal constitution, Indian Civil Rights Act, I don't know. So you're saying there's no property rights at all, or?
It's not that there are no property rights at all, Your Honor. Following this court's holding in Washington versus Fishing Vessel Association, it's not the case that an individual who has rights under a treaty or reservation can completely deprive the rights of a citizen of the territory to that same natural resource. However, it is the case that a senior rights holder may exercise that senior right to the extent necessary to fulfill their interest. Here, the Northern Tribe, as indicated on pages 6 and 7 of the record, does have an interest in preserving the livelihood of the grand trout, as the grand trout has significant cultural.
But as the amount of available water declines, it seems inevitable, maybe sooner rather than later, that the tribe is going to have the power to cut off the water to the farmers altogether.
While that may seem like the first instance of what may happen, Your Honor, what this really gets at is how the Northern Tribe is going to exercise its senior right. And here, the tribe has entered a co-management agreement with the Bureau of Reclamation and the Department of Interior.
Congress ever authorized such an agreement?
That's my question. Congress has authorized this agreement with the passage of the Reclamation Act found in 43 U.S.C. Section 383. The Reclamation Act grants to the Bureau of Reclamation the authority to oversee reclamation projects. And after the passage of the ISDEAA, which allows tribes to enter into contracts with the federal government for projects which do have some sort of bearing on the geological, historical...
Maybe I'm missing something, but didn't Hoopa versus Ryan say that the ISDEA really has to be specific as to the federal agencies? It can't be just any agency? Is there an act of Congress that fixes the Hoopa versus Ryan problem?
While I'm unfamiliar with that specific case, Your Honor, the case of Prince versus United States and Gundy versus United States has held that in situations of a sovereignty-affirming subdelegation, the specific statute which allows the federal office or entity to have authority over these, does not need to have express congressional authorization to subdelegate. Sovereignty-affirming subdelegations have been deemed constitutional by this court in matters in which express congressional authorization has not been found in the text of the statute itself.
Counsel, can we zoom out for a minute? Are you conceding that there has been a delegation of federal authority here and that the tribes aren't exercising inherent authority?
Yes, Your Honor, this is a case of a subdelegation that has occurred from the Bureau of Reclamation to the Northern Tribe. That delegation is based on the trust relationship which exists between the Northern Tribe and the United States, and that relationship has been codified with the 1857 Treaty and 1892 Land Ceding Agreement.
But doesn't the governmental function here go beyond the responsibilities to tribes and tribal people? We're talking about responsibilities that the BOR has beyond that.
Well, Your Honor, this really goes to the multiple buckets of interest that the federal government is required to meet when it comes to not only the Northern Tribe or Indian tribes, but also to the private citizens of the United States. And as this court has stated in the Colville Confederated Tribes versus Walton, when the United States is required to meet multiple interests to natural resources specifically, the federal government is allowed to reorder the priorities that it owes to these actors. Here, the Bureau of Reclamation has decided, and lawfully so, to place the priorities it owes to the Northern Tribe over the priorities of the Dakota State Farm Bureau. That is a lawful determination that the Bureau is allowed to make.
Counsel, your opposing counsel pointed out that the federal government is required to retain inherent federal functions. Did they actually do that here? It seems like they sort of gave your client the keys to the ship here and are letting him run the whole show.
Yes, Your Honor, the Bureau of Reclamation has retained review authority over the actions of the Northern Tribe in this matter. If you look at pages 6 and 7 of the record, while it is true that the Northern Tribe was the party to implement the plan which oversees the Sapphire Project, after the implementation of this plan, the Bureau of Reclamation did certify this plan, which is what allowed the Grand River flows to be reduced.
So doesn't that certification trigger federal court review because the federal agency was taking an action? Don't we therefore, as a matter of federal law, have an obligation when somebody complains to review that action?
Yes, Your Honor, this court may review that action. However, following Mahler versus Eby, for that action to be deemed unconstitutional and therefore the subdelegation itself to be unconstitutional and the exercise of that subdelegation to be deemed unlawful, there is a standard which this court has advocated and upheld. That standard is that this court must find that the actual federal office and agency did not follow its own manual and that there is evidence of the outside officer agency acting with nefarious intent when it acted against the private citizen or state actor in this case.
I'd like to come back to the congressional authorization for this delegation. I'm still not seeing it. I mean, we have Massery, which says Congress can authorize tribes to deal with liquor regulation. We've got the Clean Water, Clean Air Act, TAS status delegations. And I'm still stuck on Hoopa versus Ryan. I mean, that was actually a subdivision. It might have been Bureau of Reclamation, but it was an effort by the tribe to do a 638 contract with a non-BIA, non-IHS type agency, and the Ninth Circuit said no. There's no authorization for it. And I don't see Congress in 1902 when they passed the Reclamation Act thinking about tribes like this. Maybe they were, but I don't think so.
Yes, Your Honor. However, following the implementation of the Reclamation Act itself, there have been cases of sovereignty affirming subdelegations. So you listed a few of them. However, this court has seen cases such as U.S. versus Lara, Duro versus Reyna, Tillett versus Hodel. In each of these cases, it has been the situation in which the Department of Interior subdelegated its authority, which it was granted by Congress.
Okay, we got to talk about Lara. So that was not a delegation, but more importantly, it was something that Congress very explicitly stated. We were reaffirming the inherent power of tribes, and we're not delegating. Is there anything like that kind of legislative text that relating to the Reclamation Act or anything in Public Law 638 that would indicate to us that Congress is actually thinking about tribes in the Reclamation Act?
Well, Your Honor, the text of the Reclamation Act itself does allow for the Bureau of Reclamation to take over these projects. And if you turn to pages 4 and 5 of the record, they do allow and specifically state that one of the goals of reclamation is to allow the federal government to work with Indian tribes on matters which pertain to natural resources. Therefore, there is some form of congressional intent to allow and suggest that the federal government does want to encourage work with Indian tribes in this matter.
There's one more thing that concerns me. With your friends on the other side are saying that they have no procedural rights with the tribe. They have no political power. They have really no say. And the tribe's raising immunity, saying not only we're not going to let you talk to us in tribal court, or that we're not going to. There's no way for them to actually make the argument. It seems odd that Congress would route really important decisions to a tribal nation that will not allow anybody else but the tribe itself to make a determination.
Well, Your Honor, when it comes to how the Sapphire Project is being managed, it's worth noting that this is not a case of a sole management. As is referenced on page 18 of the record, the Northern Tribe has entered into a co-management agreement with the Bureau of Reclamation and the Department of Interior. What this means is the federal government is an active participant into how the Sapphire Project is being facilitated at all areas of this process. And this,
Also, if we look back to really the sort of basis for the tribe's rights here, what is the federal purpose that's being preserved or promoted here? And what is the tribal purpose? Are they the same truly? Because when I look at the treaty, I see a lot of specific references in Articles 4 through 7 that really go towards agriculture and development of a land base for agricultural purposes and promoting the development of an agricultural economy. There's nothing in there that really talks about habitats and fishery. It just talks about a right to continue to fish. But when you're talking about the different programs that are being administered by the tribe and the way that they're doing and the priorities, I don't see the federal purpose that's intended, that's evident in the treaty being promoted here or being preserved through what the tribe is doing.
yes, Your Honor. So this really goes to how the Winters Doctrine and implied reserved rights are taken to and have been interpreted by this court. So it's not just the explicit language that is referenced in the 1857 treaty, which states that the Northern Tribe does have and has been guaranteed the right to maintain its traditional hunting and fishing lifestyle. As the Winters Doctrine states, when a treaty references not only a tribe's ability to maintain its rights in connection with the land, but also in connection with the waters, the United States takes on fiduciary duties which attach to those waters and those lands themselves.
But council doesn't the Winters Doctrine say tribes are entitled to enough to fulfill their basic need on a reservation? It doesn't say that they get to keep a water line up for certain fish or to out hunt all of the animals. How is the Winters Doctrine trumping the interest of all of these other parties?
Your Honor, it's how this court interpreted the Winters Doctrine in Arizona versus California. So when the United States federal government removes or reserves rights under a treaty, the government also reserves the base right attached to that treaty. and the federal government is allowed to decide which party is the proper party to justify and operate when it comes to certain authorities and projects in connection to that treaty. Here, the 1857 treaty is directly implicated by the Sapphire Project. Therefore, the United States federal government did make a determination that it was the Northern Tribe that was the proper party to determine how the 1857 treaty was to be respected. And that is a proper determination following this court's holding in Heckman versus United States, as well as United States versus Jacarea Apache Nation. Because of that determination that the United States government made, the subdelegation itself was a proper subdelegation. And since
I'm glad you brought it back to delegation, because I don't think you got to finish my question before Justice Fletcher brought you back to something you'd already asked. But you said, you concluded that the delegation was proper, and that the feds reserved the right to review. But as I understand it, this was a complete, you went from 100% of the river being diverted to only 50%. So it seems like there was a big jump in the federal decision-making process from letting 100% of it get dammed up to 50%. Can you speak to that really quickly? I know you've only got 30 seconds left.
Yes, Your Honor. For this to be deemed an improper decision, there must be factual evidence that the Northern Tribe acted with nefarious intent and that the Bureau of Reclamation did not follow the manual which it is held to. Thank you.
May I proceed? Thank you. May it please the court. Firstly, sovereign immunity case law does not require magic words, as heard in Lac de Flambeau, only that Congress's abrogation is clearly discernible from the statute itself. Secondly, respondent misstated the law. This court in United States v. District Court for Eagle County held that an administration can occur while there is an ongoing adjudication. Thirdly, Senator McCarran himself stated that unless all parties owning or in the process of acquiring water rights on a particular stream can be joined, any subsequent decree would be of little value. In addition, respondents also misrelied upon the Indian Self-Determination Education and Assistance Act in this case because there is no 638 contract. It is not a relevant statute. Lastly, petitioner repeatedly conceded that the co-management agreement is a subdelegation and thus subject to subdelegation doctrines developed in this court. For the foregoing reasons, in the interest of fairness, justice, and government accountability, petitioners request that this court reject the finding of the 13th Circuit and hold both that the tribe's sovereign immunity has been waived and that the co-management agreement is an unlawful delegation of authority to the tribe. Thank you.
Thank you to petitioners and respondents. Great arguments. David. We're going to go deliberate.